and I am the hearing officer for the Sustainable Land Development Code. And today, the first thing we're going to consider is the request for that the Land Use Division staff made for a preliminary hearing in the case number 245200, Rancho Viejo Limited Partnership, Rancho Viejo Solar LLC, AES Clean Energy. And staff identified five items that they wanted to have some idea about how the parties and the potential parties might be approaching the hearing that's coming up on December 4th. And the first thing that the staff listed was what time limitations, if any, will apply to the applicant and the division staff for their presentations. And at this time, I would ask for the representative for the applicant to identify themselves and
Thank you. Yep. I do. Matt Gordon, 282 Century Place, Louisville, Colorado.
thank you.
Good afternoon, hearing officer. My name is Luke Pierpont. I'm an attorney for AES Clean Energy, the applicant.
Luke Pierpont?
Pierpont.
Pierpont.
That's correct.
Okay, thank you. Mr. Pierpont, can you or Mr. Gordon, one of you give an idea about, I have a stack of documents that I believe is your complete application, beginning with the permit and ending maybe with a hydraulic study or one of those documents. So I have that, but can you give me an idea about the number of witnesses you were planning to have testify and how long you think your presentation, and whether you'd include any additional material such as a PowerPoint presentation?
Right, yeah, so certainly we would include a PowerPoint presentation. We would request 45 minutes, and we anticipate having, would say about 6 subject matter experts prepared to testify.
All in 45 minutes? Is
Yeah.
that what
Well,
you anticipate?
Yeah, to be clear, I mean, it would be, several of us providing the presentation and then others present to respond to questions.
And since I brought up the exhibits, I would just ask that you would present the exhibits with each one of those documents with an exhibit number. And I can't remember how many documents separately there were. It seems like there might have been 19, 20. And if you would use numbers, because staff generally uses alphabetical designation letters.
Okay.
Thank you. And if there's nothing else, I'd ask for staff representative to come forward and basically give me the same information.
I do. Dominic Cisneros, 7236 Vuelta de la Luz, Santa Fe, New Mexico, 87507.
Mr. Cisneros, how many witnesses does the staff anticipate will be testifying, whether you're expert witnesses or staff?
So present at the meeting, we will have Santa Fe County Fire Department, and I believe the other witnesses will just be the applicants, or actually, no, we will also have a TAR Fire, the third-party subject reviewer, as well as Glorietta Science for the environmental.
And the staff presentation will be by, who will be on the staff that would be presenting the staff report?
It will be myself.
Oh, you will?
Yes.
Okay. And Mr. Cisneros, when do you anticipate the staff report being available?
So I anticipate having a draft ready by the beginning of next week, and then we'll get it to you for a review. We'll be also having other people review it as well before we get an actual final, but we will have the final report out by either late next week or early the following week.
Well, I ordinarily just see the final reports that are posted on, so that's all I would expect to see is the final report.
Definitely.
And that would be toward the end of next week, is that what you said?
Yes, by the end of next week or by the latest, the beginning of the following week.
And how long do you anticipate that the staff presentation will take?
I'm anticipating about 15, 20 minutes.
Including the fire department, the third-party review, the Glorieta representative?
I would probably add an additional, 10 minutes for each, so I would probably say maybe a total of 40 to 45 minutes.
Okay, thank you. The next item, I think that for that purpose, I think we have a better idea now of what the time limitations would be. I mean,
Okay.
if the applicant and staff really do anticipate being able to do these in less than 3 hours, much less than 3 hours, I think that's not at all what I was anticipating, but I appreciate the information. So I think now I'll turn to the second question, which was, which organizations and individuals, if any, will have the status of an adverse party withstanding, an interested party withstanding, or a person claiming an interest in the outcome? And to that, and Mr. Cisneros, you may sit down.
Thank you.
And to that, I would just say, at this point, the deadline, the staff gave the deadline November the 11th for anyone who wanted to submit a notice that they would like to participate in this and be considered a party or a person of interest, entity of interest. And at this point, by that deadline, I believe there were 6 motions to intervene, a request for standing. And those in order of the dates that I received them were Ashley Scheinauer, Dr. Selma Scheiveld, Lee Zlotoff on behalf of Clean Energy Coalition, Dennis Kurtz on behalf of the San Marcos Association, Camilla Braum, and Glenn Scheffbauer on behalf of the Santa Fe Green Chamber of Commerce. Staff, are you aware of any additional parties that wanted to, people who wanted to participate as a party, other than those 6?
Those were the only 6 that made the deadline of 10 a.m. on September 11th.
Thank you.
I'm sorry, November 11th.
I would just like to ask each, if, I don't know if all 6 entities are here, people, but I would like to just briefly know how long they would anticipate their case, or whether they just are participating for the purpose of cross-examination. And I would just start with Mr. Schauenauer.
I would do. It's Ashley Scheinauer, 12 Mariano Road, Santa Fe, 87508.
Mr. Schauenauer, I don't need for you to repeat your motion, which was extensive and informative, but I would like to know if you did plan to put on any witnesses yourself, if you were allowed to participate.
I would expect only to put myself on as a witness, and I would request about 30 minutes.
And you would be participating in cross-examination. Would
Yeah.
that be included in the 30 minutes?
No.
No. Okay. All right. Well, I don't intend to make a decision on that today. My intention is to make a decision on that by the 21st and let everyone who's indicated an interest know what I decided. And at that time, once that notification goes out, I'd also be asking for a brief description of the testimony and a list of the exhibits, but we'll just wait until the 21st to get to that point. And that's all I would ask for you right now. Thank you.
Okay, thank you.
And is Dr. Sheffield here? I'm sorry if I'm mispronouncing your name.
Dr. Schieveld, that's S-C-H-I-E-V-E-L-D, 227 San Marcos Loop, Santa Fe, 808587508, 87508.
And again, Dr. Sheffield, I've also read your motion, and you don't need to repeat the parts of that. I'm looking just for the information about how long you would be seeking to present a case, or whether you're just going to participate in cross-examination.
Well, I think I need time, like 45 minutes for a PowerPoint presentation, and then I would like to cross-examine about 6 witnesses.
Thank you. And is Mr. Zlotov here today?
Lee Zlotov, 53 Camarada Road, 87508.
Hello, Mr. Zlotov.
Hello.
You indicated in your notice that you wanted to participate, that your organization, the Clean Energy Coalition, represents about 1,000 members, and they are largely people who live in the El Dorado, Rancho Viejo area. Is that correct?
Yes.
And if you were to participate, how long would you anticipate your presentation to be, or would you just be cross-examining?
We would like to cross-examine, but we would also like to make a presentation, approximately 45 minutes, and we'd have approximately 5 expert witnesses, each of whom would probably speak for anywhere between 5 and 10 minutes.
All right, thank you, Mr. Zlotov.
Thank you.
And is Mr. Kurtz here?
Dennis Kurtz was unable to attend. I am on the board of the San Marcos Association. He's asked me to speak for him.
All right, and your name?
I do. My name is Doug Speer, S-P-E-E-R. I live at 100 West Pine, 87508.
And Mr. Speer, again, would you be wanting to present witnesses, or do you just want to participate in the cross-examination?
I do not expect that we would have witnesses. I would think that we would just be making a presentation, comment on the proceeding at approximately 10 minutes or so, maybe at most 15, but I can't imagine it would be more than that.
And would you be also participating in cross-examining the other witnesses?
Well, it certainly would be an opportunity. If we heard something that we wanted to ask a question, it would be nice to be able to do that.
In the notice that I received, or the request, I didn't have any idea. It indicated the San Marcos Association, which I understand is an area there in the vicinity of this proposed facility. How many members do you have in the San Marcos Association?
Well, we represent the territory that we represent as the San Marcos Association is around 7,500 people. extending all the way south of Madrid up to the intersection of 599 and Highway 14. The area that this development is in is entirely within our area of oversight.
I see. 7,500 people.
Live in the entire district of the San Marcos Association, yes.
And that doesn't overlap with the El Dorado district?
No,
That's
it does not.
total. Okay, thank you. Right. Well, thank you for that information.
Thank you.
And is Ms. Brom here?
Camilla Brom, 181 San Marcos Loop, Santa Fe, New Mexico, 87508.
And Ms. Brom, again, the question is, are you planning on making a presentation, or would you just be doing cross-examination of the witnesses?
I would like to make a presentation approximately 15 to 20 minutes, and I would like to cross-examine as well.
And do you live in either the El Dorado district or the San Marcos district?
I live in the area of the San Marcos district, and I also live a little over a half a mile from the facility, so it's really close to my home and my property, and I've been involved in this for several years.
But specifically, are you in the San Marcos Association or not?
I am a member of
You
the
are? And you're not willing to participate in the association's presentation of the case?
Well, I mean, when I say I'm a member, I'm on their mailing list, but I'm not on their board or anything like that, so I don't know that they'd allow me to do that. But I do have a social platform, a website, a Facebook, and a Change.org petition with 2,500 signatures, so I have a pretty broad group of people that I share a lot of information with, so.
On this specific application?
Yes, ma'am.
Is that what you're,
Yes, ma'am.
all right. All right, thank you.
Thank you.
And the last entity I've got is the Santa Fe Green Chamber of Commerce. Is someone here to speak on behalf?
Hi, thank you. Jill Clyburn. I do. Jill Clyburn, C-L-I-B-U-R-N, and I'm speaking for Glenn Schiffbauer and Robert Cordingley. And I wanted to clarify a few things very briefly. In terms of the hearing officers, Glenn Schiffbauer could not be here today, nor Robert, because they're at a water meeting in Albuquerque, but I was in contact with them earlier today, and there was a question. The letter that was sent to request standing was signed by both Glenn Schiffbauer and Robert Cordingley, who is the president of 350 Santa Fe, 350.org, and they intended to both have standing, individually. They wrote one letter. What I understand is that whatever you decide, they'll abide by, but that was the intent of the letter. So if you would re-review the letter just to make the best determination, it was their intention because they did not receive any notification, nor did the Sierra Club, which wanted to have standing, but didn't have the opportunity to submit a letter. So there's a great many organizations that did not have a chance to request standing. Nevertheless, I am here just to mention that, these groups want to collaborate, and if it's under the umbrella of the Green Chamber of Commerce, which serves the Santa Fe area and has a broad membership of small businesses and large. They would like to have a presentation, particularly if they have to represent other groups. So
So you don't, I don't know if you could anticipate what amount
probably a
of
half
time.
hour in all, to present the position.
And is this in a position in opposition to the application?
In favor.
In
of-
favor of the
yes.
application?
And
But
these
not-
residents, the organizations represented include members directly within the area where the project will be located, but also within the area that was party to the SLDC and its implementation.
I understand. All right. Thank you.
Okay.
I don't believe there's anyone else that submitted, so that should give us an idea of how many people have asked to participate and how much time they're requiring. I think everyone can understand the difficulty of having so many people cross-examining individual witnesses, but we'll see how this works out. Again, I'll make a decision on that by the 21st. The third inquiry that staff was concerned about was the amount of time allocated to members of the public in general wishing to speak. And I believe that we have indicated from our New Mexico courts that as little as 2 minutes is sufficient time for public comment. And I propose that there be 3 minutes for the comments, but I also am asking that the notice on this December 4th meeting specifically provide that it has to be in-person comment, that people attending by the web certainly are attending and able to listen to all of the testimony, but are not going to be able to make comment. I feel like that could be something that would be endless, possibly. And at some point, even the 3 minutes for the people in attendance in person, to the extent that it gets repetitive and redundant, there'll be a time at which we're just going to have to cut that off or at least make it much shorter time. Maybe people could sign and say that they agree with all the issues that have been brought up, something to that effect. But for now, 3 minutes will be the time that will be given to individuals who attend in person. The next was how will cross-examination be conducted? Well, it would only be conducted by parties to the case. So in the sense that there could be no other parties to the case other than just staff and the applicant. And that's when we get into the area of people able to ask questions through the hearing officer. That's how the rules are set up. If there are no people that have been admitted to participate as interveners, people with standing. And I personally have never seen that process in action as far as submitting questions through a hearing officer to then ask the witness. And if anyone has any ideas about that, I'd be happy to hear them, but that is what is called for in the rules of order for the commission and in the specific rules for hearing officer matters. So that's a little bit of an unknown. But I think everyone can appreciate how unwieldy it would be to have 10 possible different people doing cross-examination of one witness. And it's just a matter of having to weigh the amount of time that we realistically can use. And we have 1 day for this. We don't have multiple days. And it is a big application. It's a big facility. It doesn't fit neatly into the rules that work with conditional use permits. So we will, in some ways, not be able to answer how this cross-examination will be accomplished, especially not knowing right now how many interveners, if any, there will be. As far as time limitations to apply for, that would apply to parties with standing, well, I certainly don't think any party that's granted standing would necessarily be allowed any more time than the applicant or the staff. So that would be the only limitation at this point that I can see. But if we have just one day, and even starting at 9 o'clock or 10, and I don't know what staff is thinking on that matter, I think the earlier the better. And then getting in a couple of hours at the end of the hearing for the public comment, I think that's kind of a realistic amount of time. So the time limits, I think, will be just imposed by those factors as far as how much would be allowed for any party that is attending. I mean, that's being allowed to intervene as a party with standing. And with that, I would ask staff if they have any other comments or questions about this.
Hearing Officer Hebert, I wanted to clarify a comment you made just a moment ago regarding the cross-examination. Do you anticipate at this time, or have you not made a decision regarding whether cross-examination questions will all go through you?
If there are other parties to this other than staff and the applicant, I think any other party would be entitled to cross-examination of the individual witness, and I think it would just be traditionally after that witness had testified while the testimony's still fresh in everyone's mind. I don't think that it would be as useful if the entire presentation by either the staff or the applicant is made and then there would be cross-examination. So it would just be in the traditional manner of after the direct testimony, there would be the cross-examination by anyone who is admitted with standing.
Okay, thank you.
Hearing officer, staff asks that anybody given standing that has presentations to have them emailed to Dominic a minimum of 24 hours ahead of the hearing, so that way we can work with audio video people to have them queued up, ready to go for the hearing.
So that would be the PowerPoint presentation?
Yes, ma'am. Any PowerPoints that they're going to use for their presentations, if we could have those 24 hours in advance, we can ensure that they are queued up, ready to go on a day of the hearing, so that we're not wasting time trying to get presentations uploaded and ready to go.
I was going to ask, I think that's just fine, and that would be required. I was also going to ask that any entity or person that's going to be allowed to intervene would also provide a list of witnesses and a list of exhibits a week before the hearing. So that will be determined on the 21st. And did anyone else in the room want to comment here at this preliminary hearing about how this is all going to work out? Yes, please.
I did have one other question regarding public comment. Would you consider allowing other people to donate their time, their 2 to 3 minutes, to a certain individual so that person could speak longer, or is that not going to be allowed?
Well, they would all have to be here. In other words, I'm not going to allow
Right.
1,000 people out,
Right.
to be, no. Yes, I think that would be reasonable, yeah. If
Okay.
5 people want to say, we'll give our 15 minutes collectively to X, yeah, that would be fine with me.
Okay, thank you.
Mr. Schauner?
Wasn't sure, are you planning to address the issues that I identified as to be addressed at the pre-hearing?
No, Mr. Schoenauer was not, because this was basically set as a preliminary hearing on staff's recommendation and on their request. And at this point, it's not clear that you will be participating. So, no, I'm not.
So, I mean, if I were to be granted the opportunity to participate as a party with standing, when would I have the opportunity to raise these issues?
Give me an example of the issues you're talking about.
Okay.
I did read it, but I don't have it with me. I don't have it with me.
Well, redacted information. There was a substantial amount of information redacted from the applicant's hazard mitigation analysis, fire testing report, which is central really to the issues that are in front of the hearing officer in terms of the criteria for issuing the conditional use permit. They've redacted that information. I've requested that information unredacted in form through discovery requests, and they've refused to provide it, saying that there's no obligation on them to respond to discovery. But I believe that's an issue. A second, more general issue is the right to conduct discovery. I mean, this is, as you mentioned, this is an enormous project.
Yes.
It's, it's 1 square mile in size and involves a lot of issues, and they're complicated engineering issues. And so some discovery seems to be, reasonable. And I've filed a motion to compel that discovery. And I don't know if there's going to be any response to it, but I believe that issue needs to be resolved.
Well, I understand your frustration. The rules that govern the CUP process are very bare bones. And the reason, of course, that I'm considering the motions to intervene are based on constitutional due process, but I can't invent a whole discovery system for this process. So this won't be the forum that will be provided. But I would say that the fact that there's redacted information certainly must go to whether it's meeting the criteria that's imposed for the CUP. And I know that's not very satisfactory, but there's just simply there are no sanctions that are available. There's nothing that would ordinarily work in a discovery process.
Well, getting to the redacted information, there is a provision in the SLDC for the disclosure of information, even if it does qualify as a trade secret, in terms of the mitigation measures that are going to be required of the company. How do we get to that issue?
Again, there's no ability to do discovery in the CUP process, so it seems to me, a situation like that will go to the credibility of whether they've met the requirements regarding issues such as public safety and the effect it has on the public in general that is living in the surrounding. So other than that, there's no direct way at this point in this particular venue, and I just don't see that it would be anything that can be pursued in a CUP.
The role of county staff in this proceeding, I'm not clear about what that is. Are they considered parties? Is their recommendation considered evidence?
Their recommendation is considered evidence, and I believe that they're working on behalf of the public. I mean, they are employees of the county. They're working on behalf of the public, and they happen to have expertise in land use development. And in that sense, they are a party that's going to be presenting their report, and that they also can make, and have during the course of the several years this has been pending, have been seeking information from the applicant. So it's not the traditional sense of an adversary party. It's a party on behalf of the public, I think is how we would look at that. And it differs, you're familiar with, of course, the Public Regulation Commission and its staff, and they play a much more adversarial role. And that isn't the role that the Land Use Division staff plays in these proceedings. They're making sure that the application meets the requirement to come before and hear, or whether it's just so deficient that there's no point in wasting anyone's time.
Well, that is actually one of the questions that I had, and, is that I am familiar with the way proceedings work at the PRC. And as you know, there's an advisory staff, and then there's an advocacy staff. And I wasn't sure if there was a similar bifurcation, let's say, in these proceedings, whether the staff was working in an advisory capacity to you, or whether they're working as someone who's presenting evidence for you to consider.
They don't work in an advisory capacity to me. To me, I am here to hear the matter and try to keep it on course. And then in my recommended order, which of course is not the final say of the county in any means, but in that I can either agree or disagree with how staff has interpreted whether this has met the CUP provisions or not.
Then just one, I guess, related question to that is there was some discussion about when staff is going to be presenting its recommendations to you in this case.
Just let me stop you there. It's not to me. It's generally, I see the staff report when it is up on the board doc material that's posted for the entire public to see. And that's provided a week before the hearing. Prior to that, I have no involvement in the staff report or anything to do with it.
Well, I understood that they were going to be presenting their report by the end of next week or early the following week.
They may do that earlier in this case because it's such an involved case. That's was news to me.
But will that be available to the public, to the parties?
Yes, it'll be up on the internet. I speak about the internet so poorly, but will it be in the same place that where I go find it? Is that where we'll be?
Yes, it will be uploaded to board docs. And we haven't decided yet, though, if we are going to upload it to the actual website as well. That may be considered as well.
The website that all the other information on this particular application has
Correct.
been? That seems like that would be appropriate. That's what people, I guess, have been accessing.
You're correct.
Yeah, okay.
Okay, good. And then just a couple of, I guess, sort of housekeeping questions. In terms of documents that we submit, would you be requiring physical copies, or are electronic copies sufficient?
Generally, in these cases, which are much more simple than this case, it's been physical documents. And I would leave that up to the court reporter and staff to give you an answer on that. Okay.
Digitally is fine for us. I know that you prefer a hard copy, so I guess I'm gonna put the ball back in your court. We're okay digital.
All right, then
but-
that sounds fine, yeah.
Yeah.
We'll go with that.
Digital?
Mm-hmm.
Okay, good. And your order, you'll be issuing an order next week, I understand? Is that right?
On the 11th. No, I'm sorry, not the 11th, on the 21st.
And that'll that'll have deadlines on when all these things are supposed to take place, like.
It will be so far as to presenting a list of exhibits and a list of witnesses by anyone, if there's anyone that's allowed to intervene.
Will there
Be those
also,
deadline.
will there also then be a deadline for presenting any documents that we might want to present, or would that be done on the day of the hearing?
That would be done on the day of the hearing.
Okay.
Yeah.
Thank you. And just to be fair to everyone, I guess, I assume that there will be a service list prepared that when we make our filings, that we'll send it to everyone who's who's
This
been,
is, to my knowledge, this has never come up before,
Oh, really?
Mr. Schoenauer, no. No, the cases that ordinarily occur are cases such as zoning densities, setbacks. Generally, if there are attorneys involved, it may be one party will have an attorney. It's nothing, it's not set up, what you're talking about with service lists. So that's why I think to the extent that anything is submitted should be submitted at the hearing itself.
okay,
Now, for the six entities and people that have requested intervention, they will be individually sent on the 21st, yes or no, you know, with please submit your exhibit list and your witnesses by such date. But other than that, I don't think anything is anticipated.
okay, that's all I have. Thank you.
I know this is very frustrating, but it's what we have to work with. Thank you.
Thank you.
Madam Hearing Officer,
Yes.
if I can address or clarify a couple of points that Mr. Schoenauer raised for your information, and Mr. Schoenauer and/or counsel for the applicant can clarify me if I'm misstating anything. But in addition to his discovery efforts, Mr. Schoenauer also submitted an IPRA request to the county for the redacted data and documents. And I believe as of yesterday or even Tuesday afternoon, a complaint was filed in district court by the applicant seeking a protective order for those documents. So I believe at this point that that process will necessarily be handled through the district court. And I simply wanted you to be aware of
Thank
that
you.
process.
I appreciate that. Mhm.
The second point I wanted to raise concerns documents that parties wish for the hearing officer to consider at the hearing, and perhaps between now and when you send out any order resulting from today's hearing, I would direct your attention to our rules of order, which is found at Resolution 2009-2, and I believe it's paragraph Roman numeral 5D, which does call for the submission of documents that parties wish to be considered by the hearing officer, generally by no later than 1 week prior to the meeting. And hearing officer may want to have parties abide by that deadline.
And
but
you're looking at D2, identifying documents and exhibits for the record?
D1 and 2, I think they can and should be read together. The middle of paragraph 1 is where it identifies that documents are to be tendered usually no later than 5 p.m. 1 week prior to the meeting.
So not just the list of the exhibits, but the exhibit themselves?
It does reference the materials themselves rather than a list. If any party has substantial documents and might have a problem with that deadline, it could certainly make a specific request to the hearing officer about the timing, but I simply wanted to bring that deadline to your attention.
Thank you, I appreciate that, because I was thinking a list would, just a list of the exhibit would suffice. So that will be included.
Okay, thank you.
Are there any other, oh yes, how are you?
I would like to make clear that I do not ask for myself just to be an intervener, but also on behalf of the registered organization New Mexicans for Responsible Renewable Energy. which together with Camille Brom we have founded. And we have 2,500 petitions and more than 500 members. So it's not only me, but also as president of that RO that we ask for status of as an intervener. I also want to ask, am I allowed to call witnesses, or can I just cross-examine the people who did testimony or testify?
Yes, yes, when I asked, I was asking whether, I believe, whether or not you intended to
No,
call
no,
any witnesses. Would you be considering calling witnesses?
Yes.
And how many would you be?
Well, that's in the 6 people I mentioned. But can I subpoena people if I can?
No, there is no subpoena
No,
power.
okay,
I'm
so they have to be
so-
voluntary.
No, they would have to voluntarily appear.
And I understood from Camilla that it was possible that if people donate their time, that you can have extra time. So besides the 45 minutes I asked for, if there are, say, 20 people who want me to represent them, do I get 3 minutes for the 25?
At that point, you would be representing people in your organization. I would have thought that would be part of your presentation to begin with.
Okay.
I don't know, it's hard to anticipate how many people will show up. And we're trying to provide an opportunity for as many people to have a say and to have a different perspective. I think, what we'll find out is that it's a lot of repetition of the same concerns, but everyone should have some ability to either chime in. So I think we'll have to play that by ear, but I would think that if you are allowed to intervene, it would be your time and not adding in another 40 people who gave you 2 hours or something, however long that would be.
That's a pity. Thank you, I understand.
All right, thank you.
Hearing Officer Hebert, item F, that request was looked at as one request, so we would just refer back to you if you're going to consider both organizations as organizations, or persons of standing.
So that would be Dr. Cheville, that would be Dr. Cheville and Ms. Brom as being the same organization, is that what you're saying?
No, so, yeah, item F, it was the Santa Fe Green Chambers, Glenn Scheffauer, and the president, Robert Cordingley of 350.org. That was interpreted as one request.
Yes.
So we would just refer that back to you if you were going to consider both of them as organizations of
I
standing.
considered it when I read it as one request, yes.
Okay, thank you.
Thank you. Yes, Mr. Zlotow.
I'm new to this, so you'll have to forgive me, and I'm not an attorney. I have one question. If we submit presentations in advance, are those presentations going to be kept confidential by county staff, or will they be shared with everyone?
Under Open Meetings Act, they'll have to be posted 72 hours ahead because it's part of the meeting. The county is required to abide by Open Meetings Act. So they'll be part of the official record that is put online.
So we and everybody else will be able to see if they're submitted by 5 p.m. prior to the day, anybody will be able
Yes.
to see them.
Yes.
Great, I just wanted to be clear about that. Great. The other question I have is, if organizations are receiving some form of financial sponsorship or support from the applicant, do they have to disclose that when they testify or make a presentation, or is that not required?
Well, I think that would be part of the cross-examination if they're testifying, that anyone could ask them that question.
Okay,
Okay,
great. Thank you very much.
thank you. Is there anyone else that has a comment or question about how this is going to work? When will, I'm just directing this to staff, when will we know the time the December 4th hearing will begin?
Right now, the time is 10 o'clock in the morning.
And it will be in the convention center, is that correct?
That is correct.
Well, if there are no other comments or questions, then I suppose we'll probably see each other on the December 4th date, and I will get out a notice to the 6 entities that met the deadline, and I'll do that by the 21st of November. And thank you all for attending.